We have a quorum. I call the meeting to order. Please invite the administration to join us. Item number 1 is confirmation of minutes of meeting. The last meeting took place on the 18th of May. The minutes have been given to members. Secretariat has not received any proposals for amendments. Members, shall we confirm the minutes? Confirmed. Next item is meeting with the administration. Let's welcome the administration. Perhaps I will first ask to take us through the follow-up actions from the last meeting, and also a letter from the LegCo dated the 19th of May this year. Andy? Thank you. Good afternoon, everyone. After the last meeting, that is about 2 weeks ago, we had some valuable input from members. We've made some inquiries and collected some information. At the same time, we received from the legal advisor and the secretariat some questions. Last Friday, we gave a consolidated answer to the legal advisor and the secretariat. I believe you have it. There are 2 main points in our response. They are to reply to members' questions. The 2 main points are whether the exit mechanism is the best option. And the second part is related to the first one. Even if it is suitable, what about the understanding of the law related to private property, ownership of private property? We have given detailed information, but there are other questions asked. The DOJ has collected some information. The legal advisor and the secretariat would like to know more about the background, so it's about furnishing of information. We hope we have replied to all your questions in our response paper dated the 29th of May. We are aware that the exit mechanism is indispensable because we have to deal with ownership. Without an exit mechanism, there will always be just one company being the operator. 2 years ago, when we consulted the LegCo, legislators mostly raised this issue. There is no need to create a real monopoly. And if we can make arrangements to make sure there is continuous operation, then there will be all right. And an exit mechanism would be able to cater for that. And mandatory leasing, compared to other ways, is more practical. So this will be the best way to deal with asset transfer. And as to how it complies with the basic law, we have looked through local authorities, overseas authorities. They all illustrate that mandatory lease requirement to being used as asset transfer is practicable. course, we don't have to follow exactly the same as presidents. We would like to identify a suitable arrangement to resolve the issue this time. By president, I mean using mandatory lease to deal with asset transfer is not one of its kind in this case. There is some difference because different cases are different. And that's my presentation. Thank you. Thank you, Andy. I'd like to ask the Assistant Legal Advisor to speak in response to the administration's answer. Thank you. And I thank the administration for the reply. Members are aware that on the afternoon of Friday we received this, and there is quite a lot of information contained therein. There is a U.S. case, and there are also codes and also provisions of the U.S. law. So I would like to have some time so that I can look at it with the Legal Advice Division. But I would like to have some time to obtain background information from the administration. I think you're talking about CB bracket 41069/14 to 15 bracket 03. It's the Chinese version. I ask members to turn to page 6, paragraph 19. Well, if my understanding is not correct, please correct me. My understanding of paragraph 19 is that the administration endeavors to set out relevant examples in local legislation about a similar arrangement. They are Public Bus Services Ordinance, Ferry Services Ordinance, and Hong Kong Railway Ordinance. And the administration also specifically points out that, now there are a lot of similarities in these mandatory lease cases. And of course, there are differences as well. So may I first seek clarification about the background and some facts from the administration. My understanding is that in the Blue Bill, the Peak Tramway Company owned the site of the two termini. Is that right? And in paragraph 19, you set out similar cases, say Public Bus Services Ordinance. Is it the case that the public bus companies, ferry companies, or the rail or the MTRCL own the relevant sites? That's why you think that it's a similar arrangement. So would you like me to reply now, or you would like me to hear all the questions first? Perhaps, Andy, you will reply to these questions first. I believe members have other questions. Andy. Thank you, and I thank the Assistant Legal Advisor for the question. The first question, well, the ownership, as we've reported to the Bills Committee, is that there are two parts when it comes to the facilities. The termini, both termini, the sites are owned by the Peak Tramways Company, and the section in between is owned by the government. We've cited examples that there are other ordinances specifying that within a specified period of time the government may, by way of mandatory lease, to effect asset transfer. There may be different issues to be dealt with, but there are examples using mandatory lease to deal with that. Say, for example, bus. Some depots are privately owned, I mean the site, the government can invoke the law to have mandatory lease of the site. So it is the case that whether it is bus companies, ferry companies, or the railway companies, in these examples as cited, the provisions refer to a site, and the site is owned by the relevant companies, just like the Peak Tramways company owning the site of both termini. Well, I think there cannot be a direct comparison because there are always differences. There is no facility that has a uniqueness as illustrated by the tramways, because both termini are very important for the tramway. And we cited these examples to show one point. Using mandatory lease to deal with asset transfer is not one of its kind in Hong Kong. So this is to deal with your concern about setting a precedent. Even if they are the same, that would not be the case. And when it comes to the details of these cases, then it depends on which company. Say for bus companies, there are 5 franchise, and for different assets there is a different arrangement. So which particular area are you referring to?
I think for the tram company and the Peak Tram company, the trams would move along tracks, whereas for franchise buses there is no such restriction. According to the bill, does it mean that this only applies to the Peak Trams, and that it doesn't apply to all the other public transport companies? That is, if these companies should own certain sites or termini for the operation of their business. I think a legal advisor would like you to further clarify. Legal advisor, in which respect would you like Andy to further clarify the law? Thank you, Chairman. In paragraph 19 of the paper, the administration has provided 3 legal provisions saying that these are similar examples where there is a similar arrangement for the compulsory leasing of the assets. If they are similar, then they must have a similar basis for the administration to make this comparison. I note that for the Peak Tram company, in respect of the operation of the Peak Tram, the mandatory leasing arrangement referred to in the bill is actually in relation to the sites which is owned by the Peak Tram company. So what I want to know is that when the administration cite the legal provisions in paragraph 19, for these provisions which refer to some similar arrangements, my question is whether the sites in question are also owned respectively by those companies, and if so, then they would be more similar. Otherwise, if there are other arrangements, say for example, as in the case of the Peak Tram company, they own the sites, then I think the similarity would not be so much. So I would like more information from the administration regarding this point. I think what I can well, according to the legal advisor's, understanding, I think the bus company would be a very close example because the land on which the depot is located is owned by the bus companies. So in other words, for the land owned by the bus companies, then the government can nominate somebody and then compare for the site or the asset to be transferred. Yes, it will be stipulated by the government. Yes, I'd like to refer to the same paragraph, and I'd like to seek a further clarification. According to the government, although the examples arranged here are not totally the same, and that this is only a very, a rough description, could you give us more details? You may not need to spell out all the details, but could you highlight the differences and the similarities? If you say simply that they are not entirely the same, I think we would like to know where they are different and where they are the same. I think when we talk about legal provisions and for the convenience of members, I propose that I would submit those provisions in writing later on. But these are basically the details regarding the technical differences. But I think the idea is that government can take over the assets, including the land, by way of mandatory leasing. Of course, some provisions are different because each legal provision would have its respective background. Again, I have another question regarding this paper, and this time I'd like to invite members to go to page 5. The first sentence at the top. As for the new buyer, it does not constitute the confiscation of the buyer's property. In footnote 3, although the local court has not adopted the proportionality test, however, regarding the not constituting the requisitioning of the property, but however, the DFJ has reviewed whether or not the mandatory leasing arrangement is compatible with the proportionality test. According to the description here, it would appear that the DFJ should have considered some factors in relation to the proportionality test so that it eventually arrived at the conclusion that this proportionality test is not problematic. So I'd like to ask the government to tell members that indeed what factors the DFJ have considered to assist the DFJ to arrive at this conclusion. Andy, if I may defer to the law draftsman, who is the expert on the basic law. Thank you. To answer the legal advisor's question, I can perhaps make a supplement here. I think members would have noted that in footnote 3, we have cited a Court of Appeal case law, which is a recent case, actually. In the second paragraph of the footnote, members would see that we have that according to this case law of the Court of Appeal, it is very clear that in this particular case the Court of Appeal had given its opinion. That is, in the circumstances that we are now discussing, that is, there are some mechanisms which may constitute a restriction on certain properties, but it doesn't amount to requisition. And the court is of the opinion that in this case, to put it simply, it may not be necessary to cite the proportionality test. So that's what we're saying in paragraph 2 of the footnote. And in the last paragraph, we further explain that even if this proportionality test applies, and having considered that the mandatory leasing arrangement can strike a balance between the overall interests of society, that is to prevent, a single monopoly to determine the exit mechanism, and to ensure that there will not be any interruption of the peak tram services, and to ensure that the owner of the assets rights are protected. So the introduction of the exit mechanism provides for to ensure that the owner of the asset will be able to receive a rent that is pegged at the market level, even though the Court of Appeal may not need to apply the proportionality principle. But if it applies, and having considered all the factors, in this particular case, the mandatory leasing arrangement is compatible with the proportionality requirement. I also like members to note that in this case, we understand that the Peak Tram company, that is the present owner of the assets, have also agreed for the government to introduce this mandatory leasing arrangement. Having considered all these factors, this is the conclusion that we have arrived at. Any further questions? Please go on. Thank you for that clarification. I think members would have noted that the Hysan Development Company Limited versus and others of the Town Planning Board. At the last meeting, this was the Court of Appeal case law that members referred to at the last meeting, and also whether or not we need to and whether the case law involved a town planning case which sought a decision by the court. Well, I understand that the case has now been is a subject of appeal to the CFA, so I believe there is no final verdict yet on this case. Yes. Well, according to our information, the Court of Appeal has not yet decided when to have a hearing on this application for appeal. It has not yet been decided whether or not the appeal will be allowed. Well, I hope members will understand that in the legislative process, we want to be safe, and therefore, and even in this case law, it has been pointed out that in this particular case, the appellant doesn't need to deal with this issue yet, and even if it has to, it would have to, comply with the principle which the government referred to. That is, if the government wants to invoke the proportionality principle, what factors has the administration taken in consideration to ensure that there is that a balance could be arrived at, and come up with this arrangement with a Peak Tram company, and to deal with this question of proportionality test by way of legislation. That's all I wish to ask for the time being, and if I have any further questions, I will raise them at the next meeting. Thank you, Legal Advisor. I think this is a very important point. In the past, we've never had such a precedent. If we don't do a good job here, if we make a mistake here, then the operator will be encountering difficulties. And anything else that you'd like to add, Chairman? I think if, as the party, as the Bureau responsible for formulating a policy, I think we have better assurance having heard the two legal experts. That is, on the point as to whether or not we are complying with the base law, I think there are many lines of defense. Last time we debated whether or not we should do it by way of legislation, and whether or not by legislation we can impose a reasonable restriction on the assets, and the answer is yes. And the answer is yes. That is, the basic law allows the government to enact legislation to make a reasonable restriction on certain properties. And secondly, there must also be a compensation, and the compensation is the market rent. And the next question members ask is whether there is any precedent. According to the information that we've looked up, there is indeed precedents in local precedents in Hong Kong, which are very similar in nature. And I think the legal advisor also agreed to this. And now we understand that there is another case law, and that seems to be, compatible with what we are doing. It is very close to the opinion of the court. And even if we apply the last line of defense, the proportionality test, the court is saying that we don't need to be so strict. But our legal advisor is saying that even by the strictest criterion, we would be safe. So, and we will be compatible with the basic law. Thank you, Andy. I think we may now continue with our questions. Are there any members who have any questions? If not, Mr. Co-Chair, I'd like to thank the Company Secretary and the two legal advisors. I'd like to go back to paragraph 19 and come back to the question of the President. The three legislation involved the bus company, the ferry company, and the MTRC. And these provisions very often, refer to emergencies or when there are special reasons for their franchises to be cancelled. In which case, the government has the power to temporarily, take possession of the properties. Of course, the definition of property may differ in different legislation. Sometimes there may not even be a definition. Whether it refers to the means of transport or the land, and also how long is the temporary period. In some legislation, the ferry for the ferry company is no more than 2 years. It's not so clear in the other legislations. So in this case, what I'd like to ask, of course, if you don't have the information to give us a full answer, then you can, provide the answer to us at the meeting. That is, how similar are these three legislation, or can they only be applied in the event of an emergency, whereas for the peak train company we're talking about a permanent arrangement? Secondly, in the government's response to the question we raised at the last meeting, paragraph 20, that is, why can't we use a less intrusive approach by way of a lease? And the answer is that it's not possible. That is, you've consulted the Lands Department, and the answer is that there are two reasons why it can't be done. The first is that if we do it by way of a lease, it would not be legally binding on the other lessees. In other words, if the peak tram company lease it out again, it would not be affected.
And where there are disputes, then there won't be suitable mechanisms for the Lands Tribunal to arbitrate or to make a ruling. I would like to get more information. I am not an expert in this respect about land lease. My understanding is that very often for DMCs, deed of mutual covenant, it's not really about the rights of the developer and the owners. It's about subsequent owners and third-party transactions, say, for example, owners with the tenants, with management companies, or with providers of public utilities, say, for example, power companies or gas companies. There will be sufficient restrictions by way of the DMC. So we don't need a separate set of law to ensure that the right of the third party is affected. So if the provisions specifically says that it's binding on successors, just like those in DMCs, would it be feasible? And if not, why not? Andy, let me try to answer this question, and the Lands Department will supplement. Let me first answer the second question, whether it can be done by way of a land lease, that is, to put in place an exit mechanism that is more or less the same. The legislator mentioned that the subsequent owners, whether the same restrictions will apply. That can be done, yes, but it's an exit mechanism on three parts: the government and the owner, and a more important party is the new entrant. the new entrant will not be subject to the land lease. Why not? Because he was not the one who entered the agreement. But using the example of DMC, a lot of owners have not read the DMC before they purchase the property, but they are bound by it. But this is different, slightly different, albeit slightly. We are here to talk about sufficient protection of ownership of private property, and whether it is sufficient, it can be seen by way of compensation, and its compensation by market rate, and well, say the real value of the property. Say, for example, market rent. The new entrant is not party to the land lease, and whether market rental is to be paid is up to the parties, because there is no legal, there is no law to bind them. But the basic law states that the compensation shall correspond to the real value of the property. So how can we ensure that the real value of the property is paid instead of leaving it for the parties to negotiate? If there is no mandatory requirement for real value of the property to be paid, then it will not be compliant with the basic law. It cannot be done using a land lease. It can only be done using a piece of legislation. It's not the case that the owner cannot be bound by it. It's the new entrant that cannot be bound, because it will only apply to the government and the original owner and not the new entrant. Let's pause here. Let me say that I'm not an expert, but when it comes to, say, HOS, home ownership scheme units, well, very often there are terms in the agreement restricting, say, for example, sale. There will be an alienation period. Who shall the purchasers be, say, etc. I don't really understand that, but of course there are pros and cons. But if you say that if it's your concern that it may adversely affect property ownership under the basic law, well, I think you still have to choose. If you tell me that it is not possible, then I have questions. Because in our everyday life, there are similar situations, and the DMC, say, for example, imposed restrictions on the subsequent owners. There may be legal experts, say, especially those on land lease, who can give me some advice. There can be some other alternatives that can ensure us that the protection of private property is protected, just like in the basic law. Well, the DMC is not signed between the Lands Department and small owners, and I'm not a lawyer, but my work deals with land lease. The DMC is an agreement signed with the original owner by the developer. The owners will abide by the DMC. Say, for example, you can't keep a dog, and you have to pay management fees. My understanding is that the DMC will bind every owner of every unit. And Andy just said that what we're trying to achieve is to bind new entrants who is not an owner but just a tenant. And as Andy explained, even if the owner agrees to change the land lease, say, for example, the government requires this to be leased to a certain person charging the market rate, members expressed concern about protection of private property, as enshrined in the Basic Law. So how can we ensure that new entrants will pay the real value of the property to the owner, which is the Peak Tramways company? It can only be done through this bill. The Peak Tramways company is required to lease it to the new entrant. But the new entrant will have to pay market rate. But the land lease does not bind the new entrant to pay market rate to the Peak Tramways company. That's my problem, because DMC binds tenants as well. Say, for example, use of the premises, responsibilities, liabilities. They are all dealt with by a DMC. I'm not going to get into an argument with you. If there are people with legal training and who are familiar with land lease, perhaps we can seek advice from them. Mr. Mui, anything to add? This is related to land lease. It's not my expertise, so I don't have anything to say for now. Mr. Mo? We can look into it. I can't claim I have any expertise in this area, but first we have to make it clear. Say, for example, a term to prohibit keeping of pets in the DMC. Is it the tenant's responsibility, or is it something that is between the tenant and the owner? Well, that is whether the tenant is bound by the DMC or bound by the tenancy agreement. Yes, the tenant is bound by the tenancy agreement, but the owner has to make sure that the tenant does not breach the DMC. It's an indirect obligation, but it's still there. The developer signed the DMC with the regional owner, and it covers all successive titles. So the duty to be bound by the DMC is passed on. I don't know whether the land lease signed with the Peak Tramways company contains a similar term. If there is none, then we can't take this approach. Sorry. This is a new discussion with the Peak Tramways company. We can either give them a grant or we can just change the law for them. Crown rent or government rent or a new grant, all the terms can be different. Say, for example, use. So I'm not convinced that it is not feasible. If you don't mind, I would ask you to do a little bit more work so that we can rest assured. Well, let me say this again. Mr. Tse is right. He has a point. You cited the example of DMC, and I will use it. There is a DMC. All small owners are bound by it. Say, if there is a term specifying a certain use or whatever, well, I may not have entered the DMC, but I have rented a unit in this building. Usually, there is a term in the tenancy agreement stating that the tenant will have to act in accordance with the DMC, because a breach of the DMC is a breach of the tenancy agreement. So there is a premise that there is a tenancy agreement. As Andy explained, a modification of the land lease requires the government to, first of all, ask the Peak Tramways company to lease the site to a new entrant. But first, you will have to have a tenancy agreement, a lease. If we require the Peak Tramways company to lease the site to the new entrant, yes, this part there is no problem, but the Peak Tramways company is bound by the agreement. Well, you can very well ask for a charge, a market rate, but will the new entrant be willing to pay that? My understanding is that, well, the Tramways company would require the new entrant to pay market rate. And according to the law, if that is denied, then they can go to arbitration. And if there is no arbitration, it will go to a tribunal. If we use a land lease, the Tramways company will be bound by the land lease to lease the site to a new entrant and only charging the market rate. And a third part, which is the tricky part, the operator is not a party to the land lease, so the party is not bound by the land lease. In the negotiation with the Tramways company, the operator may say, I will only pay you $1. And of course, the Tramways company will not be happy. And according to the land lease, the Tramways company will have to lease the site at market rate. If the operator refuses, then they would be at loggerheads. The operator is a third party and not a party to the land lease, then the operator would be dragging the matter on because the Tramways company cannot control the operator. If we use the law, then we can deal with it. I don't understand. I can't follow your logic.
2 points I'd like to clarify. First of all, sometimes in the terms of the tenancy agreement or if there are disputes, if the two parties cannot come to an agreement, very often they can go for arbitration and normally this can be provided for. And secondly, even if you are to enact legislation, you cannot include rent into it. You can only make it a condition so that the Peak Tramway company can find a tenant. If they fail to agree on the rent, then there could be a mechanism for arbitration. So there is some flexibility there. So I don't see the difference here. So after enacting the legislation, if somebody is unwilling to lease, of course, he is willing to lease the land and he can follow the mechanism. If not, then then you will still not be able to find a lessee. So I don't see the difference. I think you've taken quite a long time already asking this question, and we have other members waiting for the turn. So Ms. Chow, could you give? I hope you can answer Mr. Chair's questions. If you're not able to provide an answer today, could you supply the answers to us before our next meeting in writing so that we can follow up on them? Ms. Chow. If I may try to explain again, Mr. Chair is very correct. In the market, there are mechanisms for arbitration, which applies to private tenancy agreements. But what is important is that you must have first signed the first tenancy agreement first. My understanding is that if I have a property unit which I want to lease to the market, if I can find a lessee, then it's only a matter of negotiation. There's no arbitration until I've signed the tenancy agreement with the tenant, and I stipulate that the rent is for X dollars. The rent will be increased after 3 years, and the rent will be raised to the market level at the time. If we fail to come to an agreement on the rent level, then we can go for arbitration. That is already a binding agreement between the owner and the tenant. 3 years later, I'll tell the tenant, now I want to charge him 2x rather than 1x dollar. The tenant doesn't agree. We negotiate, and then it will trigger the arbitration process. Of course, it will depend on how the agreement is drafted, and if we fail to come to an agreement, then the rent will be set by way of arbitration. So on day one, the Peak Tramway company and the new entrant don't have a tenancy agreement yet. But to answer Mr. Paul Chair's second question, and Andy can also supplement here, it is not a Peak Tram company going out to look for a tenant, but the government has already designated a tenant when indeed there is a need for exit. And this tenant could be Y. And Y, government will talk to Y about the operational details. But since it needs to operate a Peak Tram, there must be a terminal. And the site where the terminal are located, then it will be triggered by way of the exit mechanism and compulsory leasing. So it's like the DMC, analogy. I hope I've answered your question. It's not the biggest problem is not the Peak Tram company having to find a suitable tenant, but rather the government has picked a suitable operator to operate the Peak Tram. Then in the course of operation, other than the track land which belongs to the government and the ordinance, after the amendment, we will allow the operator to use the track land. But as for the terminal, the new entrant will have to talk to the owners of the terminal by signing a tenancy agreement. And we will rely on mandatory leasing, so to ensure that they will be able to sign the tenancy agreement. So that both parties will be bound. The ordinance stipulates that the new operator must lease those two sites. The Peak Tram company must lease it to him, and the rent must be pegged at the market level. If the two parties fail to come to an agreement, then the Peak Tram service will continue, and meanwhile, if the two parties fail to negotiate, then they can go for arbitration. I'll queue up again, and I'll make another point, with my 30 seconds. So whether it's the government helping to finding the tenant or the tenant approaching the Peak Tram company, it's the same. I think even if you didn't have a tenancy agreement before, you can have a temporary agreement. The rental could be subject to agreement if there's no agreement. So so if you go for legislation, every time you want to amend the legislation, you have to come back to this council. But if you go by way of an agreement, so long as the company is willing to show them more encumbrances, then I think it would be best that we amend the law because it's mutually beneficial. I also like to say this to the legal advisor. As how similar the other legislation are. I like to point out that they only refer to emergency scenarios. So I like to know whether or not the examples that you've provided are really so similar or comparable. Perhaps we can wait for Mr. Chair's second round before you answer that question. Whether it's the temporary tenancy agreement or the tenancy agreement. Eventually, you have to wait for the agreement to be finalized first. If it is, stipulated clearly, then we can avoid any future arguments. Sit hold. Thank you. I understand Mr. Chair's concern and the reason why he asked the question. But I would like to look at it from a different angle. And Mr. Paul Chair can also, further explain his point. If we rely on the land lease to deal with the relationship, I'm worried that the government will use its power to take back the entire operation, so that the operator who has to exit wouldn't have any bargaining power in relation to the properties he owns, because you are taking back the franchise, so he cannot operate the service. So I'm worried that this may have an impact on his private property right. So I would like to invite Mr. Chair to also have a discussion more thoroughly on this point. This is a very important piece of legislation, because we hope that for service providers who are monopolies, and if they're not performing well, we want to have a mechanism to bring in a new competitor. But then we do not want the government to have too much powers, which would encroach on private property. So we need to strike a good balance here. Chairman, in paragraph 13 I think we've covered this point before. That is, the problem could be resolved by the way of the land tribunal or arbitration, requiring the new entrant to lease a site by paying market rent. Like Ms. Chow said, the lease could be valid for 3 years, after which the rents will go up. Does it mean that every 3 years you have to go for arbitration? I would rather that the incumbent will sell the land once and for all to the new operator. If you grant a new license for 10 years for the new entrant, then you can't set the rent for 10 years because you can't predict how the rents will go up or down in the next 10 years. So to introduce the compulsory leasing arrangement may actually give rise to disputes between the incumbent and the new operator. I think it would be much better for the property to be sold to the new entrant. So the question I'd like to ask is, how long will the lease be? And secondly, when the lease expires, the two parties fail to come to agreement, they have to go to the lands tribunal or to go for arbitration. And there's no end to it. And we also understand that the new entrant can take over the necessary premises first. After the arbitrator has heard the dispute and thinks that the rent is too high, and the new entrant wants to simply, withdraw. So what can we do? So I would prefer that where you have monopolies like this, there could be a clear-cut handover. The legal advisor asked whether there have been any compulsory leasing arrangement in the past, and the government has given many examples. And we haven't yet have time to look at these case laws in detail, and we don't know how we should, make use of these case laws in our discussion. I'm worried that if there is no clear-cut transfer of properties, there might be complications which may follow. I don't think this may have to do with the incumbent being a monopoly, but this is a very unique business to compel the incumbent operator to sell or to lease his property or setting a time limit. I will ask Andy and our legal advisor to look at this again to see whether this is in conflict with the protection of private property. I wouldn't call it monopoly, but indeed the Tramway company is the sole supplier of service. So my question is that, well, on Hong Kong Island, we used to have China Motor Bus, and because the service was not satisfactory, it was asked to leave the market. And the CMB also had many depots and land. How were those properties, dealt with in those days? Could the government give us, a background? I noticed that recently the China Bus Company had a piece of land which was transferred recently. Chairman. I think here we are faced with a very unique problem. The government has spent 1 year to explore how we can deal with it in a pragmatic manner, and we have humbly listened to members' suggestions. And if we discover, we'll be happy to further consider the points raised by members. We can certainly go back to, we've actually talked to our lawyers or experts on land leases, and the conclusion was that this is the most feasible, arrangement. As to whether it is better to ask the incumbent to sell or lease the properties to the new entrant. To require the incumbent to sell the property once and for all is a clear-cut, arrangement. That's common sense. But our objective, as Ms. Ho has pointed out, is that we need to strike a balance. On the one hand, We don't want to have a monopoly which is out of control. On the other hand, we don't want to encroach too much on private property. So how do we strike a balance? Whether or not we have a monopoly. Well, to prevent that, we want to ensure that new entrants are allowed to enter the market. If the new entrant is asked to buy the two sites, then perhaps the threshold for the new entrant could be too high because to take over the operation, they have to buy the properties. And secondly, in dealing with the private property, I don't think we should adopt a drastic approach. Regarding the protection, prescribed in the basic law, we've talked to the DFJ. He's indicated that the incumbent said that he's not willing to sell the land, but he's willing to lease. It doesn't mean that if he doesn't agree, then we cannot have legislation compelling the sale or the leasing of the properties. Now, since we have a practical problem here, I think it would be all right so long as we can resolve the problem. I think the point is that you have the right to use the land. You may not have to be the owner to operate the peak tram service. If we could achieve this result, have we already achieved the purpose of the exit mechanism? The answer is yes. So this is therefore incompatible with the law. It would also so we therefore think that compulsory leasing is a feasible option, and it also helps to strike the right balance. At the last meeting, members also made the point that I think only the base of the terminal was used as a peak tram station. You also have an office tower on top, which has nothing to do with the tramway operations. Should we combine the office floors and the peak tram station? But the government is now suggesting that the owner doesn't need to sell the property, and also the property to be leased will be the part at the lower portion.
Andy, we asked this question last time, and it seems that you haven't given us a proper answer. You now say that the owner would lease it, and if there is no agreement reached, there will be arbitration. And you still haven't touched about the offices above. Now, a legislator raised the issue of sale. So is it just the sale of the ground floor or the building above as well? Well, it's very clear. We don't need where we don't need it. So we only keep the bare minimum to keep the operation of the tramway. So it's called essential premises, and we will reach a written agreement with the Peak Tramways company to clearly delineate what constitute essential premises. Basically, we're talking about the terminus and where people queue up to buy tickets, and it's nothing to do with the office. And at the peak, it's nothing to do with the building either. It's just the area where people get off and get on. Nothing to do with the shopping mall either. So when it comes to the use of the land owned is kept to a minimum. And as to whether land lease is to be used or the law is to be used, I don't know whether it will help with the discussion. You are a lawyer, so you have more professional knowledge than we do. When we are discussing with the DOJ, of course, we will ask our lawyers again. if we don't know who the lessee is, and we don't even have a lease agreement, well, there will be a lot of uncertainties. We have to minimize the impact on private property. We don't know how much compensation will be made and whether market rent will be can be collected. We have to minimize the impact to a minimum. The owner think that using it this way, the impact on them will be kept to a minimum. Even if it works, we still have to work out the details with them. So far, the owner itself think that it affects them in an insignificant way, and they find that acceptable. So can the government speak to the operator? Is it the case that when they have a new lease, they will have to go to arbitration? It will adversely affect surface stability. Well, the land is owned, and if it's not used for the tramway and instead it's used for something else, well, then it's their own consideration. But for the future operator, the only thing that would affect them would be the rental. So every time there is a new lease, the operator may leave because of the high operating cost or unfavorable conditions. And of course, the best way is for the government to buy the land with the market rate and then lease it to the operator, whoever it is. This will provide stability. There are relevant provisions in the law. We hope that you will not deprive the land. You can, well, then you, and in this way you can charge market rate or not. You have to very carefully consider the issue of private ownership. When the government resume or acquire land all over the territory, we've seen a lot of controversy. But in this case, there is the interface problem. If there is a change of operator, whether it's a sale or not, and how the lease is to be dealt with, they are separate issues. The rental value and the market rent, well, there is already a mechanism in place. We have to look at it in different perspectives. But we can't possibly cover all the different scenarios. We can only cater for the general principle. Andy, thank you. Well, let me supply you with some information. The term of the lease is to be decided by the CE in Council according to the law. When we draft the bill, we keep in mind transition. There should be an exit mechanism, and there should be seamless transition. And if they can work it out themselves, then then it's great. And if the terms are not accepted, the CN Council can allow for the operator to enter and start operation first. For service stability and continuity, well, we have to take the term into consideration. Say, for example, if 10 years is granted, then it will be 10 years. And over the 10-year period, how much rental should be paid? Well, we ask for that to be a market rate. So the point of contention is what mechanism to deal with rental and the term. If you suggest a certain amount and the other party find an expert to say that the market rental is actually a different amount, then the two parties will take the matter to arbitration. And it's not the case that they will try to stall by not furnishing information. So we have a mechanism for a third party to make an arbitration. And as to whether a party will be aggrieved as a result, and I think it's the spirit of an arbitration to accept the result of arbitration, and that is also a term they have to accept before arbitration starts. The owner has indicated that they accept this option, and once there is a change of hand, the subsequent new entrants will be subject to the same restrictions. So the owner will only be affected once and not by subsequent entrants. And at this point of time, the owner expressed that this option is acceptable. So I think the current mechanism has afforded some kind of protection when it comes to service stability. And in the letter, we have cited some examples, and I'd like to take this opportunity to reply to Mr. Tse's first question. That is, whether it's only in emergency situations when this approach is taken for the government to take over the asset. Well, there are provisions about public bus services, but when it comes to the expiry of a franchise, the government can also take the same approach. And when it comes to railways, where at the expiry of the franchise, the government may take over any assets, say for example land, cars, and equipment. So there is a specific period of time when these issues are dealt with. So there is a specified period, and the approach is mandatory. And as to some terms are longer than others, it depends on the need. For public transport, so MTRC, the franchise is 50 years. So it would take a major incident for a change of operator. For others, there may be shorter terms to deal with the emergency situation. But it's more to deal with a strange phenomenon created by a lack of exit mechanism. But with an exit mechanism, it doesn't mean the current operator has to leave. But we can't explain away if the law doesn't deal with it at all. So the difference is a difference in terms and length of time. and we will furnish you the information after the meeting. No law is perfect. And well, I don't think we will be able to resolve the issues, whether it is sale or lease. Perhaps Andy can give us an answer next time. And I'd like to ask the legal advisor if she has any questions for you. I thank the administration for citing precedents in paragraph 19. And I'd like to give some supplementary information. In Cap 230, Cap 140, and 556, first one is Public Bus Services Ordinance, second one Ferry Services Ordinance, and Hong Kong Railway Ordinance. They all have a specified period. If the government is to take over, there is a maximum period of time when the government can hold on to the premises or the asset, and whether there is a possibility of extension. Where I stand to be corrected, my understanding is that, say, for buses, according to Section 25(3)(a), it says to the effect that it will not be longer than 3 years, accumulatively. Not more than 3 years, and on each occasion not more than 2 years. And under Cap 104, on each occasion no more than 2 years. And the LegCo can by way of a resolution extend it, and every extension should not be more than 6 months. And under a Hong Kong Railway Ordinance, it will not be more than 2 years, and for every extension no more than 5 months, and is to be decided by CE in Council. So what I can see at first glance is that members are right, and the administration is also right. There is a specified period of time. It's a restriction. It may be extended, and the period may not be like what is stated in the Blue Bill, that is for the CE in Council to decide. We understand that the CE in Council will have to refer to the premise in the Blue Bill, and is my understanding that a 10-year is used as a basis, maximum of 10 years, yes. And if an existing operator would like to continue operating, then 3 years before the expiry of the 10 years, the existing operator will have to indicate an interest in continuous operation and submit improvement proposals and prove that they will indeed improve the service before they are allowed to continue.
In
that case, I understand that it could be for 10 years, or there is only 3 or 4 years remaining in the franchise period. I think the still 10 years is the basis. Looking at the bus companies and the ferries or the MTRC, the duration may be shorter, and in some cases, LegCo may have a role to play here. Namely, that the government can come back to ask Council for a resolution as to how long the extension should be each time, and stipulate that it should be no more than 6 months. So members may wish to also bear this in mind. Mr. Yik Chiming. Thank you. I understand that in the government's response on page 7, they refer to the 2 sites owned by the Peak Tramway Company, and the terms apparently seems to restrict the use of the site, which has to be for the operation of the Peak Tram, but then part of it could be used for residential purpose. Supposing that the Peak Tramway Company want to exit and someone want to take over, then only then we will have the question of takeover. If the Peak Tram Company wants to leave and there is no new entrant, then how are we going to deal with this site? Because the Peak Tramway company owns the site. Can it apply to the town planning board for a change in land use, pay a premium, and use it for other purposes? Chairman, the way the lease is drafted says that the operator can operate, peak tram services on the site, but that is not mandatory because it can also do other things as whether or not it needs to apply to the town planning board. We will have to look at the requirements in the town planning ordinance. Well, that's my question. I understand that the present owner will continue the operation, therefore they are accepting your proposed terms. But as a third party, after you've imposed this condition, and once the incumbent wants to give up the operation of the peak tram service and you've identified a new entrant, but the incumbent cannot go for redevelopment because he is compelled to sell or lease the site to the new entrant, does it mean, would it affect the value of his assets now? That would depend on whether during the redevelopment the peak tram depot would be affected. I mean, that is only my personal opinion. Andy. On the peak, well, the peak tram is a recreational facility. It is also a shopping mall where you have pedestrian flow. The tramway is a tourism facility for the peak tower. I think the passengers are taken up to the peak tower. So with the tram service in operation, it actually can help preserve the value of the property on top. At the lower level, there is an office and a peak tram station, and there's no need for the both functions to complement each other. So the compulsory leasing arrangement only applies to a sports, piece of land, which is where the terminal is and the structures there. As whether or not it would affect the value of the office properties, apparently it's very difficult to come to a conclusion. Apparently there is no connection. That's my understanding, and I'd like to ask whether Ms. Howe has anything to supplement. I don't have anything further to add, Chairman. Having heard Ms. Chow, the land lease at the moment can be used for tramway related services or other uses which are not related to tramway services. So suppose one day, if I'm the tramway company, I want to give up the tramway business. I would like to convert it to other uses. Right now, property on the peak is sold at $100,000 per square foot. So I changed my mind and I want to give up my tramway business. But according to the condition here, if anyone is interested, I will be compelled to lease my property or sell it to the new entrant. So for the shareholder of this company, will the shareholder value of this company be affected by this restriction? I may be wrong. I just want to, ask experts. Andy. Again, I would like to ask whether the Lands Department would like to supplement. I think to answer the member's question, your question is that if this scenario should arise, what's going to happen? I think the problem which the government has to address is that at this moment the peak tram company has indicated that it would like to maintain and continue with the operation of the tramway service. In the course of formulating our policy and also when we drafted the bill, our focus was how we can maintain the status quo. You said that the land or the site has development potential. My understanding is that any change of land use are governed by relevant rules and legislation. What we are most mindful of is that just in case we need to use the site, we are proposing to deal with it by way of leasing arrangement. And we want to ask whether the owner has sufficient protection. I think the fundamental guideline here is that according to the basic law, we have to ensure that he is fully compensated. And what the bill proposes now can achieve that purpose. Ms. Chow. Also like to clarify the point I didn't, explain clearly enough. For the two sites on the peak, according to the lease, if it is not used for peak tram related services, he is not allowed to use it for any purposes. For example, on the peak, the site cannot be used for residential development. I understand, but he can apply to the town planning board for a change in land use. Of course, the board may not approve the application. Another question. Suppose the two structures there become very dilapidated one day and needs to be redeveloped. But the company still wants to operate the peak tram service, but because of the need for redevelopment, I'll have to stop the peak tram service for 3 years. I'll resume the service after 3 years upon completion of the redevelopment. Would it be allowed to do so? I think the franchise at the moment, I think says that the Seeing Council will approve the franchise having considered all the relevant factors. So as in the case of any redevelopment plan, if the incumbent put forward a redevelopment proposal and we need to adjust the franchise period, then right now the Seeing Council can extend the franchise by 10 years. Mr. Yik is saying that, well, I think redevelopment would not be, something that you want to decide overnight. Though in the course of development, if the incumbent can see that by a certain time it's the time for the building to be renovated and so on. So this is something that he would have to, bring up when we negotiate the franchise. And according to the law, the Seeing Council can take all factors into consideration. Using your example, for example, if all the parties agree that the tramway service has to be suspended for 3 years and that only this company can come up with this arrangement and nobody can do it within a lesser time or shorter time, then can the Seeing Council consider the 3-year period and impose a condition? Let's say because the track land belongs to the company charges a premium. So there could be some arrangements there to take care of this scenario. So I think the mechanism can deal with that. Thank you. Mr. Paul Chair, your second round. I think they haven't answered some of the questions you asked earlier. I would like to invite you to ask your other questions before they will give a global overall response. I think regarding the reference value of the three legislation, like our legal advisor had pointed out, please also give us more details regarding the duration. The bill, the government has tried its best not to tailor-made it for the Hong Kong Tramway Company. There is still the approval mechanism. I don't know whether this is a hypothetical question, just in case the bill becomes the law. Of course, we know that the tramway company will apply for renewal, and in theory, we would extend the franchise. But what happens if we have a new CE or new administration which will stick to the rules and have to vet the application again? For the peak tram company, so what safeguard does it have? Apart from, I think in the course of negotiation, I think there is a question of reasonable expectation. There might be litigation, but once you've set the rule, I mean, in theory, you can at any time, award the franchise to another company. Well, Mr. Chair, being a lawyer, had indeed looked at this very thoroughly. Indeed, this bill is not tailor-made to any party. Our objective is to ensure that the legal framework is sound, and that is the major focus. But we've always stated that it is our policy not to resort to other means to find a newcomer. We see that the Big Tramway company has a good track record. It also has a plan to make investments to improve the service. So policy-wise, we want to go, well, this is something that we've arrived at through direct negotiation. And once the bill becomes the law, once the government has power to renew the franchise, then we can very quickly engage in a negotiation with the Big Tramway company and decide on the terms. So I think members can rest assured that this can be done. Another question raised by members was about the duration or the tenure. How can you resolve the problem? Well, I think the previous administration, I think we have greater confidence in the administration. But in the light of the granting of a TV license, apparently the government's policy and the government having considered a basket of factors have actually created more uncertainties. Of course, I can't represent anyone, but as for anyone, any undertakings made or gentlemen's agreement arrived at, there is no legal guarantee. So the government may promise you many things, but then it may renege on its promises later on. I think we've been in dialogue with the Tramway company all along. Have you been in dialogue with them?
議員都去問，即係我又未用過咁嘅問題問過。
Well, I haven't really asked the Big Tramways company the exact question, but we've been in discussion with them for over a year. My understanding is that their main concern was, well, please give us the approval as soon as possible. And they understand that at the expiry of this term of government, then we won't have the authority to discuss with them. And if, God forbid, it would take longer for the bill to be endorsed, then it might happen. When I think by safeguard, is not the case that they will have nothing left. Is our policy in direction to start negotiation with them and to negotiate the next franchise, which will last for another 10 years? Well, will this be a reasonable expectation as in the law? We don't think so, because the law states very clearly that the government has no power to grant it. So it is not for the government to approve it. Well, on one hand, you said that it's policy that they will get it, and at the same time, you say they shouldn't have any reasonable expectation. Well, what I meant was that the government would start negotiation with them according to the prevailing law. And about the term, the mandatory leasing, and how is it different and how is it understood with the existing law? When we go to the clause by clause, we will give you the detail. But for now, I can say that for 11B1, it says clearly that the CE in Council can may order in relation to essential premises arrangements. But still, the CE in Council has to act in accordance with certain restrictions. the directions should be reasonable. That means that the peak tramways will have to play its function of a facility that serves tourism. And recreation. As I've said before, that the period granted is once for 10 years. If it's less than 10 years, then it will be a shorter period. And the similarities with the authorities is the specification of a certain period, and it's not set arbitrarily. Under the existing law, well, it can be renewed. That means there won't be an end date. And you see this is related to the peak tramways serving its proper function. It's very difficult for me to answer you as to whether why it's not 3 or 4 or 5 years. Now that's my reply. Mr. Tse, anything to follow up? It may be rare in reality, but if you have to take into account the financial situation and experience in operating tramways, that means the MTRCL can apply to be an operator. If there is more than one applicant, what are you going to do? Andy. It's a very good question. We've actually thought about it as well. The law, the provision states that relevant factors will have to be taken into consideration, and it's not that the CE in Council has to take into relevant factors, and we have not set them out. Say, for example, the terms proposed, the capability, financial soundness, and experience. Of course, when it comes to experience, no one can rival with the existing operator. So that is an advantage enjoyed by the existing operator. Well, maybe in the end, when it comes to financial soundness, it's down to their parent company. And they will be more or less similar. So it's what they can offer, because it's precious land. We will not only look at what they offer, just the rental. If the terms they offer is reasonably generous, well, we will consider that. And of course, we keep in mind that the fact that the company operating for over 100 years has been operating the service well means that they are not trying to continue for the sake of continuing. But if there is indeed a true arrival, we will have to weigh up all the different factors before we decide. Any other questions? If not, let's go into clause by clause. In relation to questions asked by members, we'll continue next time to deal with them when we have answers. Well, I want to ask, say, CMB, they have left the market. They own land. A lot of the sites have been turned into residential blocks or commercial premises. Well, can we draw reference from that to so that we can get a glimpse of what possible changes there will be? Perhaps we start clause by clause. Andy or Carrie? Carrie, Miss Chan will take us through the clause by clause. Thank you. If you refer to page 1 of the blue bill, you will find the object of the bill. Some of it has been discussed by members about the grant and termination of operating right starting from a certain year, and the properties as lease or sale of properties that are essential to the operation of a peak tramway. And the bill is also to provide for the transfer of policy responsibility to the Secretary for Commerce and Economic Development. Since the 1980s, the peak tramways has become an important recreation and tourist facility. So we've also taken the opportunity to update some obsolete provisions. Any questions so far? Now we move on to part 1, clause 1. The title. Clauses 2 and subclause 2 and 3, it states the effective date of various provisions. Some of the provisions applies to the existing operation, and some applies to the from the 1st of January 2016. So you see that some provisions will come into effect on the day when this ordinance is published in the Gazette. Clause 2. You will find the relevant amendments. Part 2. Clause 3 is an amendment to the long title. Clarifications has been made to clarify the scope of application. To provide for the grant and termination of the operating rights of the peak tramway to regulate the operation of the peak tramway has been added. Clause 4. Amendments and updates on the interpretation. They include the definition of company. It will be changed from Peak Tramways Company Limited to the body corporate to which the operating right is granted under this ordinance. So after the 1st of January 2016, the CE in Council may grant operating right to an eligible and interested operator. Another important change is the interpretation of secretary, so that when there is reference to secretary, there is no need to state the full title. And as I've explained at the outset, the policy responsibility will be transferred to the Secretary for Commerce and Economic Development. So the definition of the Secretary means the Secretary for Commerce and Economic Development. The interpretation of operating right means the right to operate the tramway. Now we move on to Clause 5. It is to repeal Section 2A. The reason for repealing this provision is because the Section 2A empowers the CE in Council to grant operating right until this year. And this provision has been implemented, but 2A will only be repealed on the 1st of January 2016 because the current franchise will expire just before that date. Clause 6. It is to add 2B and 2C. 2B is to empower the CE in Council to grant the operating right in any manner that the CE in Council thinks fit to an suitable body, starting from the 1st of January 2016. And it also sets out the procedure and the factors to be considered by the CE in Council, as well as the information to be supplied by applicants. We have adopted the same framework because we've always used 10 years as the basis. We consider that we need to provide for operating stability so that proper arrangements can be put in relation to operation and also investment. So in subclause 1, we specify that normally the period of the operating right will not exceed 10 years. So the CE in Council has the power to grant the operating right and is subject to conditions agreed with by the body corporate.
2B1 and 2A in the existing ordinance are consistent. Next, we come to 2B2. The government is clarifying here that the operating right may be granted to not only the incumbent operator but also any other body corporate that does not hold the operating right. 2B(3), in deciding whether or not to grant the operating right to a body corporate, what factors the CE in Council has taken into account. The CE in Council must take into account all relevant matters, and we've given some examples here. And Mr. Chen already mentioned some of these examples. For example, the terms proposed by the body corporate, whether it has the ability to maintain the Peak Tramway as a major tourism and recreational facility, whether it has the financial ability, its track record, and so on. At previous meetings, we've mentioned also that the tramway may, from time to time, need to be replaced or renovated. So in the bill, we've introduced a mechanism for the incumbent operator, that is, if it is intended to make an investment to enhance the system, and such enhancement can help enhance the facilities, and it can apply to the CE in Council for another 10 years of operating right. So the maximum duration of an operating right could be 10 years plus 10 years. In proposing these enhancements in 2B6, it is said that it will stipulate the information which the operator has to submit to satisfy the CE in Council that it has the commitment and the ability, and that its proposal is conducive to the long-term development of the Peak Tram service. 2B7, the operating right may be granted to a body corporate within the meaning of the company. The operating right, of course, has to be satisfy the other provisions of the Peak Tramways Ordinance. And there is something unique in the bill, that is the power to grant the operating right. I think at a certain time, the Sitting Council will lose that power, and that's why we need to have, a second stage legislation, in order that that this will not happen again. In 2B9, we provide clearly that to avoid doubt, the power under subsection 1 or 5, bracket 5, may be exercised in relation to a body corporate more than once. In other words, after January 1st, 2016, the Sitting Council may exercise such powers repeatedly in granting the operating rights. Mr. Chairman, I'm looking at 2B bracket 3. That is the factors which the Sitting Council will need to take into consideration. As most of these are about the quality of the body corporate and its ability and experience, as well as its proposals for enhancement. What I'd like to know is that for these important or such important powers to grant the operating right should rest with the Sitting Council. But has the government considered this? That is, in considering whether to grant such operating right, what is the role to be played by the public? For example, for the Central and Western District Council or the Peak constituency. Or even the legislature, where the bill is silent. So for such powers to grant operating right for different public transport companies, if the law is silent, does it mean that the Sitting Council and the operator, in the course of the negotiation, they will not consider public opinion at all, or that they will not consider the views of the legislature, the district council, and other organizations which may want to put forward the views to the Sitting Council? Or does it mean that the Sitting Council can totally ignore such the views of such stakeholders? And eventually the decision can only be based on a whole basket of factors that the Sitting Council can then decide. Thank you, Mr. Chen, for the question. We have always, all along, consulted the District Council whenever we grant any new operating rights. Nowadays, I don't think we can get away if we don't come back and consult the councils. So when the government, grant any new operating rights, and once we receive any proposals, and also we will need to come back to the relevant panel in this council to give an account for members. So you can rest assured about this. And District Council is also very concerned about this, and we will certainly consult them. I don't think he has answered my question. We all know that I'm not asking what we're doing now and what we will do in the future and so on. And even if you don't ask, they would. So what I'm saying is that in the decision-making process, since the law does not require the Sitting Council to listen and adopt the views of the operators, the body corporates, but you say that the Sitting Council have to consider a basket of factors. So strictly speaking, there's nothing we can do if the Sitting Council doesn't consider all those factors. Or would the Sitting Council, is it the case that the law doesn't require the Sitting Council to consider any other factors outside of the scope of bracket 3, bracket A to E? Well, we're mindful of the fact that all of us have our own wisdom. So these are the important factors that we have thought of and provided for in the bill. After many years, whether new factors may appear that we cannot think of now. And that is why we've deliberately, worded the provisions in a broad manner. So, for For example, we say that in deciding whether or not to grant the operating right to a body corporate, the CN Council must take into account all relevant matters. So we are placing this responsibility onto the CN Council that it must consider all relevant factors. The 5 examples, the 5 items here are just examples. It doesn't mean that the CN Council will only need to consider these 5 factors. So what we're saying is that the CN Council must take full consideration all relevant factors. So what does all relevant factors mean? According to the bill, it means the term proposed by the body corporate, representation made by the body corporate, whether the body corporate will be able to maintain the tramway as important tourism and recreation facility, financial capability, and also any relevant experience and performance of this body corporate. So all along, all relevant matters would only include what you've stipulated in from 3A to E. In vetting other bills, I think we've come across revisions which are drafted in a rather lax or lenient manner, and there is some leeway so that to cater for unexpected scenarios. So, and I agree with these 5 factors, but what I want to know is, other than these 5 factors, would there be other matters which the CN Council would likely take into consideration? If it is not in the bill, I'm not questioning your motive, but since you've not provided for them in the bill, then the law, it would mean that the law doesn't require the CN Council to consider anything outside of these 5 factors, even though many people may have reservations. But the law doesn't require the CN Council to consider those other factors. So this is my inquiry. I dare not say that I'm challenging the government. Andy. I think the policy intent is very clear. I think we fully concur with Mr. Chen. That is, all relevant matters are not limited to these 5 factors. As to how, regarding the drafting aspect, I'll ask the law draftsman to further elaborate. I think the present draft is the all-encompassing approach that we've adopted. The wording of this section would not result in the court interpreting all these relevant factors to be confined to these 5 factors. If that is the case, normally we would clearly stipulate that the CN Council will consider all the 5 factors rather than all relevant factors, including the 5. So we say considering A, B, C, D, E, and all other relevant factors. I think one principle is that after A, B, C, D, E, I also put in a factor F, any other factors. The interpretation is that they should not deviate too much from A, B, C, D, E. If we adopt this approach, A, B, C, D, E, and plus other factors, that is not as encompassing as the present draft. So according to the present draft, we are already placing a legal responsibility on the CN Council to consider all relevant matters, and it's not up to the subjective judgment of the CN Council, but rather objectively all relevant matters must be considered. And if the CN Council doesn't act within reason, it could be challenged. So when you draft a bill, sometimes it depends on the policy requirements. So here we are laying down an objective standard. So the present draft is actually better than saying that the CN Council must consider A, B, C, D, E. It requires the CN Council to consider objectively all relevant matters. If one looks at E, for example, 3E, any relevant experience and performance, this, I think, indirectly can means the track record of the body corporate. So in assessing its track record, I think public opinion will play a role here. Chairman, I may need some time to digest this. Of course, I have not participated in the vetting of many bills, but I recall that in other legislation that it's no, if the government said that consultation is a necessary step, and in the course of consultation and when the government collects public opinion, and the government will have the intention to reflect all such opinion collected to the Senior Council, then I would prefer to be more safe. And I think why don't we say that, stipulate that views collected during public consultation should be taken into consideration. I may need to think about this, but I wonder whether or not we can do something here to ensure that at least in the course of vetting this bill, we are discharging our duty to ensure that the Senior Council can simply not seriously take take into consideration public opinion. So, Andy, could you go back and think about this? But to be fair, Andy has not said that the other consultation is not important. But since Mr. Chen has made this suggestion, could you go back and consider whether you could expand the scope here and come back to us at the next meeting? Chairman, that is a good suggestion. I can perhaps consult with the law draftsman whether this suggestion of mine can allay Mr. Chen's concern. Could we add not limiting to including but not limited to the following factors? Well, I think only the law draftsman can say what he said just now. But I wonder whether we can add a few more words and to further clarify this section.
Andy. Well, if it's just including but not limited to is quite widely used, but it's no longer in line with our modern approach of simplifying the drafting and using only the minimum necessary so that it will not get verbose. But anyway, our drafting practice will not stop us from adding words that members deem necessary. Mr. Zhang, I agree with Mr. Mo. Well, new laws are not as verbose. Including means including but not limited to. We won't use save and except, because in the past when it comes to drafting of the law, one tends to be convoluted. The language tends to be convoluted. Well, this is for your reference. Please consider it. We'll stop here now. We will continue with 2C. The next meeting will be at 8:30 in the morning on the 29th of June. So far we have one person signing up in the public hearing.
Deputation.
One deputation. So, will the current operator coming? We have sent out the invitation, I believe. That if there is only one deputation coming, then we'll see how we will proceed. We've also invited the Bar Association, but they said that they would not attend. Members, would you like to make any suggestions, any issues? If not, meeting adjourned.